Dear friends, the video part 1, we deliberated upon the gist of the judgment, and wherein this honorable judge, learned judge, analyzed the case, which I have explained. But we are going into the details, how from the angle of counsel for the appellant, and also from the angle of the public prosecutor, how the case could have been established. The case is basically dealing with 375 rape and then consensual sex as defined under 90 of IPC. Now, the person was found guilty, the accused, and is serving rigorous imprisonment. And he appealed, that is the sessions court, it has come, and then he was found to be found guilty, and 25,000 fine and rigorous imprisonment, 10 years was given. Now it's come under appeal before this honorable judge. Now we are trying to understand how this honorable judge analyzed it. If you see, it's a very good analysis. How first he took, yes, this is a case of rape, and it is a heinous crime against women. And we know in our culture, when a girl is raped, they would not like to make it as a big issue because fearing the social consequences, and they'll suffer themselves. It creates huge mental trauma on the persons. Then this is a soft touch. We have to give top priority to the fair sex. That he has recognized, lordships. But at the same time, based on the facts and circumstances of the case, their lordships have come to the conclusion, this is not one of that case where a helpless woman has been subjected to such a heinous crime. But this is a willing person, after having associated with the accused for quite some time, and consensually giving her consent for the acts of the A1. Suddenly turned back and then decided to punish him. And here our interest is how the judge's mind is working. So the learned judge also said that no doubt the person should be given maximum consideration, possibility of rape being there. But at the same time, the events and circumstances that are taking place in the society, where the law should not be misused. Between these two, and then based on the evidence which is to be established beyond all reasonable doubts, and it is a very tough judgment. But as I told you, the judge's ability to understand the things very fast has, I think, helped him. I leave it to you, this analysis. But in my opinion, it's a well-judged judgment. But I would like to look it from the angle of the counsels, youngsters practicing. What are the gaps that prosecution has left out, or the situation itself beyond the control of the prosecution, and how that genuineness or otherwise by the accused, who was able to establish his innocence because beyond all reasonable doubts. So how was this judgment framed? The short summary of the judgment starts from para 25, wherein from para 26 to 28, the learned judge emphasized the importance of giving maximum consideration to the submissions of women, particularly in case of rape, as our culture is prevents the affected persons from approaching the law enforcement agencies. And at the same time, the learned judge focused on the instance of misuse of the provisions of the court law and provisions of the law to settle their vengeance when the facts and circumstances of case refer to the misuse of the judicial process. Now, he pointed out that the abuse of process of law seriously impacts the life and liberty of a male innocent person. And this honorable judge set the issues for adjudication. Para 29 to 33, the learned judge detailedly analyzed the section 375 and section 90 of IPC and focused on the issue of consensual sex as defined or determined by the Honorable Supreme Court under section 90 of the IPC, based on which the AA1 was seeking the acquittal. Para 35 to 38 of the learned judge 38, the learned judge relied on the following citations. Permanent Solutions, Volume 8A, page number 205. What does it mean, consent in the cases attracting Section 375 IPC? And then citations relied on the Apex Court as well as Kerala High Court. Harinarayan Singh versus State, Vijayan Pillai versus State of Kerala, Jayanti Rani Panda versus State of West Bengal. Para 939 onwards, the learned judge focused on the material placed for adjudication with an intention to find out whether the prosecution made out a case against the accused beyond all reasonable doubts, and whether the evidence establishes the twin conditions laid down for attracting Section 90 of IPC, namely 1, the consent given under misconception of a fact. The person who obtained the consent knew the consequences of such misconception is the second ground. In the case on hand, PW1 knew that A1 is married and having a child. Marriage with A1 is therefore not possible in spite of the promise. Even there is no evidence, iota of evidence, which the prosecution failed to establish. All right, when suppose if the person is saying that I'm going to divorce my wife and I'm going to marry you, then there is a cause of for believing that person. So there is no such evidence established by the prosecution, which is fatal to the entire case of the prosecutrix. This is a very important point the counsels must realize. The Honorable Judge, to get this possibility, relied on the evidence of witness that both were in deep love and was meeting A1 at 12 o'clock in the night, which establishes the consensual sex. Thus, the court came to the conclusion, relying on the judgment of Uday by the Apex Court. The deposition of the doctor, which confirms that for the past 1 month, both of them were having regular intercourse and that there is no resistance or injuries on her person or body. That was another clinching evidence in favor of the A1. The deposition of the doctor, which confirms that for the past 1 month, both of them were having regular intercourse and that there is no resistance or injuries on her person. That is it. The investigation officer took 40 days from the date of filing the complaint. So the learned judge took it as a very, very important thing on the assumption that they could have been marital, trying to bargain for various things, citing this. So therefore, that 40 days every day delay took place has been a clinching evidence in favor. And the learned judge strongly commented upon the practices followed by the investigation officer, though he doesn't want to comment upon that. It gave the indication that this could have been the basis for those people making, various bargaining techniques, marital content. Then we are going to the this girl in the nights, she used to take a different route which nobody can see, and then going to meet him to have the etc. So therefore, that shows that is another point which lordships have analyzed. That is a consensual only. When you are interested in that matter, now after all of a sudden giving the excuse of marriage denial, all that things, it's not a strong evidence which the lordships have taken. And the learned judge further analyzed the possibility and likelihood of A1 taking advantage of such meetings by forcing on. Now, okay, though you are extreme situation, you say, no, I went because he's promising to marry me, so I would like to sit and talk to him. I don't have any interest to have sex before marriage. That stance he could take. But then he took the issue that their doctor's deposition shows that there is no force, there is no bodily injuries, etc. So therefore, he said that mere fact you are doing like this, it is a situation giving an option for the opposite person to act upon you, which is considered as very beautifully analyzed in this one. So these are the basic grounds on which I will take up in the part 3 a detailed analysis. This is from the viewpoint of the practitioners of criminal law. So we can have a deliberation how we could have come out of each and everything in the witness, how to cajole. Normally, nobody is independent witness, and in this case, they are relatives. So they are not being told how to go about it. In other words, when the defense takes that stand, the prosecution should have concentrated on the vital weaknesses in the case. I'm not saying that innocent person should be punished, but I'm talking from the angle of a counsel. And the counsel for the accused is extremely capable. One, Mr. Karthik, he really, on that day itself, I put a chance to look at the way in which he presented the case, made the judge feel that this is a case worth giving. On the basis of 100 innocent culprits can go scot-free, but one innocent person should not be punished. Thank you, friends.